Okay, so good afternoon, everyone. My name is Fariza Mukanova. I'm an Associate Crime Prevention and Criminal Justice Officer at the Chemical, Biological, Radiological, and Nuclear Terrorism Prevention Program of the Terrorism Prevention Branch of the United Nations Office on Drugs and Crime. It is my pleasure to welcome you all to today's webinar, the 8th in a series of 10 webinars discussing key aspects of the International Convention for the Suppression of Acts of Nuclear Terrorism, or ICSANT. I would like to express UNODC's gratitude to the European Union for enabling this series of important virtual discussions on ICSANT and for its partnership in supporting our long-standing efforts to promote the convention. ICSANT serves as a cornerstone of the global nuclear security architecture, representing the first international legally binding instrument to criminalize illicit use of radioactive sources. The Convention enables states parties to prevent, investigate, prosecute, and adjudicate certain unlawful and intentional conduct involving nuclear or other radioactive material, devices, or nuclear facilities while upholding human rights and the rule of law. In criminal events involving nuclear or other radioactive material, international cooperation and relevant technical assistance are essential to facilitate effective responses. So ICSANT provides a strong framework for states parties to request assistance from other states parties as well as relevant international organizations such as the International Atomic Energy Agency. Such assistance can be provided for preventive purposes as well as for managing post-crisis situations involving nuclear or other radioactive material, radioactive devices, or nuclear facilities. So today's webinar will look at the role of the International Atomic Energy Agency under ICSANT and discuss the relevant assistance that the agency can provide to states parties to the convention, in particular in relation to its Articles 8 and 18. Indeed, the IAEA is assigned specific functions under ICSANT, which were approved by its Board of Governors in 2007. We will discuss these functions with my colleagues from the IAEA, Ms. Victoria Rosten and Mr. Jonathan Herbach, who are joining us today and whom I will introduce shortly. On behalf of UNODC, I would like to extend our appreciation to the IAEA, particularly to the Division of Nuclear Security and to the Office of Legal Affairs for the continued fruitful cooperation in promoting universalization and effective implementation of other relevant international legal instruments against nuclear terrorism, namely the Convention on the Physical Protection of Nuclear Material and its 2005 amendment, which we do through joint awareness-raising initiatives as well as through contributions to each other's relevant capacity-building activities within our organization's respective mandates. Now, allow me to begin the substantive part of the webinar with a brief primer on ICSANT. So just give me a second to share my slides. Okay, so you should be able to see it. Thanks. Let me start with a short historical background on the convention. So negotiations were called to address gaps in international legal framework for preventing and responding to nuclear terrorism. ICSANT was elaborated by an ad hoc committee established by the United Nations General Assembly in 1996. It was adopted by General Assembly almost a decade later in 2005 and entered into force in July 2007. Its depository is the United Nations Secretary General. The convention currently has 127 states parties. Now, ICSANT is one of the 19 international legal instruments against terrorism, which UNODC promotes in line with the mandate conferred to it by the United Nations General Assembly. These instruments have a similar structure. Specifically, they require states parties to criminalize certain offenses identified in the instruments under their national law. They establish instances of jurisdiction, both mandatory and optional. The instruments also include an obligation to extradite or prosecute, and they provide legal grounds for international cooperation between states parties for extradition and mutual legal assistance purposes regarding the offenses they establish. In some cases, they also include other forms of cooperation. So in the following slides, I will discuss these four aspects in relation to ICSAND. But before doing that, I would like to first highlight the scope of application of ICSAND. It should be noted that the Convention scope of application is limited to offenses that have a transnational element. It means that the Convention is not applicable with some limited exceptions if the offense is committed within a single state, or if the alleged offender and the victims are nationals of the same of that state, if the alleged offender is found in the territory of that state, and if no other state has grounds to exercise jurisdiction. It should also be emphasized that ICSAND applies only to acts by non-state actors. Specifically, Article 4 of the Convention contains exclusions from its scope of application. It stipulates that activities of armed forces during an armed conflict, activities undertaken by military forces in the exercise of their official duties, or use or threat of use of nuclear weapons by states are to be governed by other rules of international law, disarmament, arms control, and non-proliferation regimes, respectively. So ICSAND only applies to acts that are committed by non-state actors. The Convention also defines key terms under its scope of application. It defines radioactive material as substances that naturally emit radiation and which may, owing to their radiological and fissile properties, cause death, serious bodily injury, or substantial damage to property or to the environment. Radioactive material includes nuclear material and other radioactive substances. And by Convention, nuclear material refers to certain forms of plutonium and uranium, or mixtures containing them, as you can see in the definition provided on the slide. In most simpler terms, or for ease of understanding, nuclear and other radioactive material is commonly in use in many countries in various fields. So they can be used for power production, medicine, agriculture, industry, research, or other sectors, and they help to improve the quality of people's lives when used for peaceful purposes. But if misused, they may have grave consequences, and that is why it is important to have strong legal frameworks around this material. ICSAND also defines nuclear facility as any nuclear reactor, including reactors installed on vessels, vehicles, aircraft, or space objects for use as an energy source for propelling such vessels, aircraft or special objects, or for any other purposes, or as any plant or conveyance used for the production, storage, processing, or transport of radioactive material. So, for example, a van transporting a radioactive source from one point to another is considered a nuclear facility under the Convention. And the device is defined as a nuclear explosive device or radioactive material dispersal or radiation emitting device that may cause death, serious bodily injury, or substantial environmental or economic consequences. These are so-called dirty bombs. And now looking at the offenses criminalized by ICSAND. ICSAND establishes offenses involving radioactive material, radioactive devices, or nuclear facilities where they have been committed unlawfully, that is, in the absence of a legitimate justification, and intentionally, that is, deliberately. these offenses range from illicit possession or use of nuclear or other radioactive material or radioactive devices to damage to nuclear facilities, and they also include a series of ancillary offenses. The full list of offenses to be criminalized pursuant to this convention is provided in its Article 2. It is important to note that in order for an offense to fall under ICSAND, it needs to be committed with a specific intent, and those include the intent to cause death, serious bodily injury, substantial damage to property or to the environment, or the intent to compel a natural or legal person, an international organization, or a state to do or refrain from doing an act, and that is so-called terrorist intent. Moving on, another key element of ICSAND is jurisdictional obligation. Pursuant to Article 9, states parties are required to establish jurisdiction over the convention offenses, specifically instances of mandatory jurisdiction as based on territoriality or active nationality principle, as well as some cases of optional jurisdiction. Further, the convention stipulates that the state party in which the alleged offender is present shall either extradite the alleged perpetrator to another state party that claims jurisdiction over the offense, or prosecute the alleged offender. And these obligations on jurisdiction and on prosecution and extradition aim to allow as many states parties as possible to prosecute the offenses and deny the creation of safe havens for alleged perpetrators. As I mentioned earlier, the convention facilitates international cooperation in criminal matters and provides legal grounds for extradition, mutual legal assistance, information exchange on such offenses, among other forms of cooperation. And these provisions are important given the transnational nature of offenses that fall under the scope of application of ICSAND. Now, I mentioned the extradite or prosecute principle. Further, Article 13 of the Convention provides that offenses under ICSAND shall be deemed extraditable offenses in all existing and future extradition treaties among its states parties. If there are no extradition treaties between states parties, ICSAND may be considered as a legal basis for extradition in respect of the offenses set forth in the Convention. ICSAND also provides legal basis for mutual legal assistance. Specifically, its Article 14 mandates states parties to afford one another the greatest measure of assistance in connection with investigations or criminal or extradition proceedings in respect of the offenses established under the Convention. Now, ICSAND also offers a strong cooperation framework for preventive measures and post-crisis situations. Oops, I moved too fast. Including for requesting international assistance from other states parties or relevant international organizations such as the IAEA to ensure the security and safety of radioactive material, facilities or devices seized following the commission of an offense. Article 7 of the Convention contains international cooperation mechanisms for preventing, detecting, suppressing, and investigating offenses under the Convention. It requires states parties to do so by exchanging accurate and verified information and by taking coordinated actions across borders. This article also contains an obligation for a state party to inform without delay the other state party about other states about committed offenses or preparations or planned acts, as well as to inform as appropriate international organizations, including the IAEA. Further, paragraph 2 of Article 7 requires states parties to take appropriate measures in accordance with their national law to ensure confidentiality of any information that they receive. And if information is shared with international organizations in confidence, then there should be also steps should be taken to ensure the confidentiality of such information as well. Article 7, paragraph 4 of ICSANT requires states parties to designate their competent authorities and liaison points responsible for information exchange. It also requires the United Nations Secretary General to inform all states parties and the International Atomic Energy Agency of the points of contact designated by the states parties. Now, UNODC is in charge of receiving and disseminating notifications made by states parties pursuant to this article, and we fulfill the obligation by making the notifications of POC designation available on UNODC's dedicated ICSANT website, and that information is regularly updated. I would like to also mention that just last week we had a webinar that specifically discussed the role of points of contact under ICSANT, and if you will be interested to check that session, its video recording is available also on our website. And my colleague Jonathan will also discuss a bit more about the IAEA's role under this article later in his presentation. Now, Article 8 refers to functions of the IAEA, which will be discussed in more detail again by Jonathan. So I will not go into its details. Similarly, Article 18. Article 18 explains what states parties should do when they seize or take control of radioactive material, devices, or nuclear facilities after an offense under ICSANT has been committed, and it covers certain provisions relevant to the IAEA, and yeah, they will be also elaborated by Jonathan in his presentation later in the event. So for now, I will skip the details of these articles. Before I conclude my presentation, I would like just to update on UNODC's technical and legislative assistance. As I mentioned, we support states with adherence to and effective implementation of ICSANT. We do through a range of outreach and capacity building activities, such as awareness raising with policy and decision makers to sensitize them to the importance of the convention. We help train criminal justice and other relevant officials of states parties so they can effectively put the convention into practice. We offer workshops, mock trial exercises, judicial trainings, as well as tabletop exercises. And we developed a range of capacity building tools and we also provide legislative assistance and have relevant tools available at the disposal of states to help them bring their counterterrorism and relevant legislation in line with the requirements of ICSANT. And yeah, this is just a snapshot of our technical assistance library, which includes a large number of tools and resources, all of which are available in all 6 UN official languages. Some of them are also published in other non-official languages. I just would like to draw your attention to the most recent resources that we developed. These are toolkits on specific aspects of the convention, including one on model criminal provisions covering the offenses set forth on ICSANT, the CPPNM and its 2005 amendment, as well as a toolkit on synergies among ICSANT, the CPPNM and its amendment. So these resources are available on our website, and you can access our website through this QR code. This is a repository of all resources and information on the convention, which we operate in all 6 UN official languages, and regularly update the information contained there. So this is the end of my presentation. If you will have any further questions, please feel free to reach out by email on the emails shared on the screen. So I will now stop presenting, and I'm pleased to once again welcome the speakers of today's webinar, and I would like to finally introduce them. First, we will hear from Jonathan Herbach, who is a legal officer in the Nuclear and Treaty Law section of the IAEA's Office of Legal Affairs. Before joining the agency, Jonathan served as a senior policy officer within the Division of Non-Proliferation, Disarmament and Nuclear Affairs at the Ministry of Foreign Affairs of the Netherlands. Prior to that, he was a research fellow at the Center for Conflict and Security Law and a university lecturer in law specializing in arms control law and nuclear security. Jonathan holds a PhD in public international law from the University of Amsterdam in the Netherlands. Then we will hear from Victoria Roston, who serves as a nuclear security officer within the IAEA Division of Nuclear Security. Victoria has over 15 years of experience in nuclear security. Before joining the IAEA, she was responsible for nuclear security policies at the Nuclear Regulatory Authority of Argentina. Victoria holds a bachelor's degree in political science with a focus on international relations from the University of Buenos Aires, and has completed postgraduate studies in international economic relations. She is also a WINS certified nuclear security professional specialized in regulation and communicating with civil society. So Victoria and Jonathan, thank you for joining us today. Before we proceed to the presentations, I would like just to note that the format of the webinar will not allow for a Q&A session, but if participants will have any questions or would like to share any feedback on the session, please direct them to us by email to unodc-ixant@un.org, and we will get back to you also by email. Now I would like to give the floor to Jonathan for his presentation on the role of the IAEA under ICSANT and specifically on provisions of the convention which are of particular relevance for the agency. Jonathan, please, you have the floor.
Thank you so much, Fariza, and thank you to you and the UNODC team for inviting us to participate in this interesting webinar as part of this webinar series on a very important legal instrument. So we're very happy to be able to participate and discuss the role of the IAEA. So I'll share my slides. Which
yes,
hopefully you can see.
It's on.
Good.
Yes, all
wonderful,
good.
wonderful. You never know, even though we've got a lot of experience in these types of webinars, it's still always unsure
Absolutely.
if you're able to see the presentation.
Yeah, all good.
So great. So I'm from the Office of Legal Affairs at the IAEA, so I'm going to talk kind of about the legal aspects here, the relevant provisions of ICSANT for the IAEA, these functions that ICSANT assigns to the IAEA, as Fariza has already introduced, and to talk a little bit about the role of the IAEA in that legal context to start out with. And then Victoria will talk more about the role of the Division of Nuclear Security. So just to start, I wanted to highlight that the IAEA plays a central role in strengthening the nuclear security framework globally. This is something in general when it comes to nuclear security, which is an area that deals with prevention, detection, and response to criminal or other unauthorized acts involving nuclear or other radioactive material, associated facilities, and associated activities. So this role is based in the statute of the IAEA and reflected by decisions of our policymaking organs. So when we're talking about this area, nuclear security, the legal framework that is sort of the foundation of nuclear security is constituted by a number of different instruments, both legally binding and non-legally binding. ICSANT is a very important legally binding instrument in the context of nuclear security, as is the Convention on Physical Protection of Nuclear Material and its 2005 amendments that was already, both of which were already mentioned. So these are three actually legally binding instruments in this area, but there are also a set of non-legally binding instruments that are very crucial to this framework, and actually very important when we look at the provisions of ICSANT in just a moment. So ICSANT is part of this broader legal framework and has then a number of synergies with the other instruments, including the CPPNM and its amendment. The CPPNM and its amendment are the main legal instruments in the area of nuclear security adopted under the IAEA's auspices. So the Director General of the IAEA is the depositary for the CPPNM. So these synergies have to do primarily with respect to criminalization provisions, but there are some certain other elements that are also part of these synergies among the instruments. And so I wanted to start in this way to kind of give a bit of context to the role of the IAEA in this area more broadly, and why it makes sense for the IAEA to have functions assigned under ICSANT. So when we look at the provisions of ICSANT, Fariza highlighted some of these key provisions that actually make reference to the IAEA specifically. And among those are these paragraphs in Article 18, where following the taking control of radioactive material following the commission of an offense, that steps will be taken in managing and protecting material, either in retaining the material or returning the material to another state's party, kind of depending on the situation that is related to the material at the time. And then paragraph 5 encourages the IAEA to provide assistance to the maximum possible extent when it comes to taking these steps to protect the material, to ensure that it's done in a safe and secure way, to render it harmless, to ensure its return or disposal. So all of these different aspects, it's possible for the IAEA to be called upon to provide assistance. And the assistance that the IAEA can provide in this respect has a number of different aspects, and Victoria will discuss those in more detail. But this is in particular a provision that encourages the IAEA to provide assistance. Paragraph 6, then, when it talks about the context of either disposing of or retaining the radioactive material, device, or nuclear facility as defined under ICSANT, the state's parties will inform, are required to inform the Director General of the IAEA of the way in which this item has been retained or disposed of. And the IAEA Director General will then transmit the information to other states' parties. So this is directly a function that's assigned to the IAEA by ICSANT. Fariza mentioned that these functions were approved, these additional functions were approved by the IAEA Board of Governors, because of course the IAEA is not party itself to ICSANT. And so these types of functions that are included in ICSANT had to be approved by the executive body, the Board of Governors of the IAEA, in order for the IAEA to undertake these functions. So this is an important way in which the IAEA can be involved in facilitating certain steps that are to be taken under ICSANT with respect to radioactive material, protecting it, disposing of it, retaining it, returning it, all of these steps where the IAEA can play a role. There are then a number of other provisions of ICSANT that refer to the IAEA, are relevant to the IAEA, or refer to the different recommendations, standards, safeguards of the IAEA. So Fariza mentioned the obligations of states parties under Article 7 that has to do with information exchange among states parties, and where appropriate, international organizations with respect to the commission of the offenses, providing that type of information in confidence because of the sensitive nature of this type of information. And then also informing other states parties of competent authorities and liaison points with respect to ICSANT, which is done to the states parties, but also to the IAEA, and the Secretary General of the United Nations takes those steps. So as part of this information exchange, the IAEA will receive information under this article. And when it comes to the confidential nature of the information that might be provided to the IAEA, we do, of course, have mechanisms in place to ensure the confidentiality of information that's exchanged with relation to nuclear security incidents. Another important article that's relevant to the IAEA is Article 8, which obliges states parties to make every effort to protect radioactive material. And this is to be done taking into account relevant recommendations and functions of the IAEA. So the IAEA is specifically referred to in this article. It's an obligation of conduct, so taking every effort to adopt appropriate measures. And this reference to recommendations, I think, is very important to highlight, because, as I mentioned, the legal framework for nuclear security is composed of both binding and non-legally binding instruments. And there are a set of non-legally binding guidance documents that have been established under the auspices of the IAEA in what we call the Nuclear Security Series. There's a set of recommendations. There are 3 recommendations level documents in the Nuclear Security Series related to physical protection of nuclear material and nuclear facilities, and also another recommendations document that is about nuclear security of radioactive material and associated facilities. And so I think, although these specific documents are not specified in Article 8, when you read the terms of Article 8 referring to relevant recommendations, these are the types of documents, guidance documents that you would think of. And these, because ICSANT covers radioactive material as a broad category, so nuclear material as well as other radioactive material, I think Nuclear Security Series 13, which is on physical protection of nuclear material and nuclear facilities, as well as Nuclear Security Series number 14, which is on radioactive material and associated facilities, are both very relevant here because they provide guidance on the steps needed to protect and secure these types of materials. So, in fact, if you look at Nuclear Security Series number 14, it actually makes reference to that guidance document helping states implement their obligations under ICSANT. So this is a very important article. And then I wanted to highlight as a last article here, Article 18 again, but referring to, in particular, paragraph 1 of Article 18 that makes reference to different instruments under the IAEA's auspices. So it makes reference to IAEA safeguards, ensuring that nuclear material that is taken control of following the commission of an offense is held in accordance with relevant IAEA safeguards. For those of you who aren't familiar with safeguards, the safeguards instruments, the agreements, are for verifying essentially that material used for peaceful purposes is not diverted to nuclear weapons or nuclear explosive devices. So that's important. Every state has some form of IAEA safeguards in place. Almost all states have some form of IAEA safeguards in place. There's also reference made there to physical protection recommendations. I already mentioned what these are in the context of our nuclear security series. And it also references the health and safety standards, which is on the nuclear safety side, but provides guidance in relation to radiation safety, radiation protection, so protecting people, workers, the environment from exposure to radiation risks. These are guidance documents that are established by the IAEA and are applied to our own operations and to agency-assisted operations. So they cover the safety side. So this paragraph really covers safeguards, security, and safety aspects contained within the instruments established under the IAEA's auspices. There's also paragraph 4 of Article 18, which talks about the disposition of radioactive material devices or facilities when they don't belong to any states or they're unlawfully obtained from the territory of a state party, or there's no party that's willing to receive these items, that consultations will be undertaken regarding the disposal of these items, including with the IAEA as one of the possible relevant actors in this sense. So those are the main provisions that directly relate to the role of the IAEA. And then I wanted to turn very briefly to some of the assistance that we provide in this respect. Because I'm from the Office of Legal Affairs, I'm talking about the agency's legislative assistance in particular, because Victoria will talk more about the technical assistance that the IAEA offers. But when it comes to legislative assistance, the IAEA provides assistance to our member states in adhering to international instruments and in establishing national legal frameworks to give effect to obligations under the international legal instruments. And the way we do that is through awareness raising, through reviews of national legislation, through capacity building, training of lawyers, and so on. But I wanted to highlight in particular the Handbook on Nuclear Law, which is one of the main resources that have been developed to support states in establishing their domestic legal frameworks. And the volume that we have on implementing legislation, it's volume 2 of the Handbook on Nuclear Law, includes model provisions for implementing criminalization aspects of the relevant international legal instruments. So the model provisions that are provided in the Handbook on Nuclear Law cover the CPPNM, its amendment, as well as ICSANT, and also the Terrorist Bombing Convention. And this is an example of our close cooperation with UNODC, because these provisions on criminalization in our handbook were developed jointly with UNODC. So just to wrap up my brief remarks here, as I mentioned, there's no single instrument that covers nuclear security in a comprehensive way. There are a number of legally binding and non-legally binding instruments. ICSANT is one of the key legally binding instruments in this area. The role of the IAEA with respect to the legal instruments, we're the depository for the CPPNM and its amendment. And we're assigned then, of course, these functions under ICSANT, and there are provisions that are of relevance to the agency and the role and functions of the agency under ICSANT. We provide assistance to support states in strengthening their legal framework for nuclear security, and really working very closely with UNODC when it comes to these promoting the universalization of these instruments, because only through universalization of ICSANT, the CPPNM, and its amendments, will we get as close as possible to eliminating weak links, which would allow perpetrators to evade justice for crimes and terrorist activity involving nuclear or other radioactive material. So thank you very much. And if there are questions, as Farisa said, I'd be happy to connect by email if there are further questions on this. Thank you very much.
Great. Thank you, Jonathan, for the very comprehensive presentation highlighting these specific functions that ICSANT assigns to the agency and the importance when looking at ICSANT within the broader international legal framework for nuclear security. You also referred to synergies among ICSANT, CPPNM, and its amendment. As I mentioned, we recently released a toolkit, and my colleagues have shared the link in the chat box, so you can also consult this resource. And also for highlighting the relevant recommendations and guidance documents that may help states parties to implement the obligations under ICSANT. I think those were also very useful. So thank you so much. And I would like now turn to Victoria to further discuss the role of the agency and in particular technical assistance that the agency can provide with reference to relevant provisions of the articles that Jonathan just discussed. So I give the floor to Victoria, and I will share the presentation from my side for you.
Thank you very much, Farisa, and thank you so much also for sharing the presentation due to my technical issues. So thank you for stepping in, and thanks also to UNODC for this opportunity, for inviting us to present during your webinar. And so continue with what Jonathan just presented, and I will focus more on the technical side of this assistance that the IAEA provides here at the Nuclear Security Division. So if you could move. Thank you so much. So this is just as an overview of our nuclear security support program, what we do. We will see this in details in the next few slides. So first, we facilitate adherence to international legal instruments, but also implementation of these international legal instruments related to nuclear security. So for that, we will have the nuclear security series guidance publications and the technical documents, as Jonathan introduced first. The NSSP, we will see what all this is, and apologize for the acronyms, but we will see it later on in the next few slides. We also provide peer reviews and advisory services, information exchange tools for member states or state parties according to their needs, and analysis as well. We also have coordinated research projects. We provide education and training. We have also a number of e-learning modules in different languages, official languages of the UN. And we also support states in upgrades of technical capabilities, risk reduction, and also at major public events. And the IAEA stands ready to assist state upon request to meet their international obligations, to reduce the risks, and respond appropriately to these threats. So if you could move to the next, thank you so much. So as I first mentioned, the first item in the list was to facilitate adherence to international legal instruments. So Here at the IAEA, we mainly focused on the universalization of the Convention on the Physical Protection of Nuclear Material, the CPPNM, and its amendment, here at the division, I mean, and we facilitate the adherence to, but also the implementation of these two international legally binding instruments. But as a part of our program, we also provide different services that could also help implement other international legal instruments. So what we do here, especially focus on the CPPNM, but again, it's also useful for ICSANT and other instruments like the 1540 United Nations resolution, Security Council Resolution 1540, is to raise awareness. To increase understanding, we also organize regional and national workshops, international seminars. What we try to do here is to increase understanding from medium level of officials and high level of the decision makers separately also on the importance and the benefits of joining and effectively implementing the CPPNM and amendment, as well as other international legal instruments. We facilitate this implementation. As Jonathan mentioned before, we have a program of legislative and technical assistance. I will go more into details regarding that. And we also have reference material, mostly related to the CPPNM amendment if you go to the nuclear security website, but also, as Jonathan mentioned, we also have the handbooks on nuclear law, where you can find the rest of the international legal instruments. If you could move to the next slide, please. Thank you. And this is probably the most important part of the presentation, because this is the direct link between what Jonathan presented regarding the role of the IAEA under ICSANT. So as he mentioned, the IAEA provides key guidance and support to state parties in the prevention and response to offenses involving radioactive material and nuclear facilities. And as the convention, the ICSANT specifically refers to the IAEA recommendations, this is the main slide connected to ICSANT. So as Jonathan mentioned, we have the nuclear security series. This contains the fundamentals. Then we have 3 main documents, which are the recommendations, and then we have also technical guidance and implementing guidance. And these nuclear security publications are developed in close collaboration with experts from member states. They participate in our Nuclear Security Guidance Committee, which is open to all member states. They provide the recommendations on the development and revisions to be made to these publications. And the important thing to mention here is that this nuclear security series, what we call NSS, this provides international consensus guidance to support the states in establishing and maintaining an effective nuclear security regime, including fulfilling international obligations under the CPPNM as amended and ICSANT. The other, Jonathan mentioned 2 of the recommendations. The other one, the number 15, is the recommendations on nuclear and other radioactive material out of regulatory control, which is also has includes some relevant elements related to ICSANT in case material falls under the wrong hands and then is found out of regulatory control. So if you could move to the next slide, please. Thank you. Then we also provide advisory services. These are a few of the acronyms that you saw at the beginning. So we have the IPAS missions, INSERV, and RIS. These are International Physical Protection Advisory Service, INSERV, the International Nuclear Security Advisory Services, and the Regulatory Infrastructure for the Radiation Safety and Nuclear Security, which is combined, which is more on the interface and combined nuclear safety and nuclear security. So this is, again, upon request of member states, and it's available here at the division. Could move to the next slide, please. Thank you. So we also help states in the prevention of a nuclear security, what we call a nuclear security event, which is a crime which is related to nuclear or radioactive material. So for that, we provide guidance and assistance to improve physical protection systems. We also assist countries in transport security, what we call IMAC, which is Nuclear Material Accounting and Control, specifically for nuclear security, which is totally different from the one they have in safeguards because of the amount of material is different. In case you are not aware of that, for nuclear safeguards, we take a different number of material and amounts, and for nuclear security, this is all included in our material categorization, which you can find in NSS 13, the nuclear security recommendations on the physical protection, as Jonathan mentioned before. Then threat assessment, we also assist states in that, and nuclear security culture. Could move to the next one, please. Thank you. For detection and response, we also provide assistance on nuclear security detection architecture for states to develop a detection architecture. This is more related to what we call MORC, which is more related to NS 15, as I mentioned before, which are the recommendations for nuclear and other radioactive out of regulatory control. So in order to detect this material that could be, again, out of regulatory control, we help improve this detection architecture within the countries. We also assist them upon request when they are hosting or organizing a mature public event. And regarding response, we also provide assistance in nuclear forensics to identify the materials and where they come from, and radiological and chemistry management as well. We move to the next one, please. Thank you. So related to information exchange, what the IAEA offers here at the Nuclear Security Division is our incident and trafficking database, the ITDB. So the ITDB mainly assists states to exchange information on incidents that involve radioactive material or nuclear material that were subject of unauthorized activity or illicit trafficking, for example, of theft or robbery, or when material appears appears in a specific location without being under regulatory control. So in that case, what the states can do is to share the information with the IAEA. They fill in a form, and the IAEA shares only with the point of contact to the ITDB. This is on voluntarily basis, it's not mandatory, and it's something that helps sometimes countries to identify material that has been lost and probably found in another place, in another country, at another location. So it's also useful to interact with other point of contacts. And it also helps us to keep a record of the nuclear security incidents when they are related to when the material appears or disappear because of a nuclear security event, or it just disappear because it could you go? Well, thank you. So when the material probably it didn't fall necessarily on the wrong hands. Sometimes what happens is that it's subject to a criminal act, but that is not related or is not aiming at the material itself, but for example, as directly as at a transport. So most of the events here do not have a criminal or an intention behind that, behind the theft itself. Not with the intention of trafficking with the material. This is what I meant. But it also helps us to see to identify threats and a pattern of how these events happen, how many of them are because there is an intention of trafficking with this material, and how many others happen without having an intention behind. This is the main point. So you could move to the last one, I think. Thank you. So related to capacity building, we provide a number of different events here at the agency, but also at our Nuclear Security Training and Demonstration Center, Cyperdorf in the NSTDC. We also provide a number of different international schools We will be adding new ones in the near future. We have the nuclear security schools, but you also have the schools on drafting regulations. E-learning, as I mentioned before, in this tool that maybe we can share the link afterwards. We include a number of modules related to, for example, the categorization of the material, regarding all these publications, regarding the CPPNN amendment, a variety of subjects that are relevant for this conversation. And I can find the link before we end the session so I can share it with the participants. And many of these e-learning modules are also not just in English, but also in the rest of the UN official languages. And I think that's it from my side. Yes, that's my email if you need any further information on this. Thank you.
Thank you, Victoria. Just let me stop sharing the screen. Okay. Thank you very much, Victoria, for this informative presentation as well, and for sharing the different type of assistance that that the agency can provide to states parties to ICSANT and how such assistance can be requested. It was also very useful to be aware of nuclear security series publications, the guidance documents, for preventing and responding to incidents involving radioactive or nuclear or other radioactive material. So it was very insightful presentation. Thank you so much. I think we had a very engaging discussion that helped us unpack the functions that ICSANT assigns to the agency. I'm hopeful that participants also found it useful and learned more about the types of assistance that is available to them under the convention and how the IAEA can support in certain defined situations. So this brings us towards the end of our discussions. I would like to thank Victoria and Jonathan for their time today to discuss the role of the IAEA under ICSANT and to inform us on the range of assistance that can be provided to states parties to the convention. I would like to thank the audience for joining us today. As mentioned, we welcome your feedback and any questions that you may have. You can send them to us by email. Lastly, I would like to thank the European Union for its financial support to UNODC, which make events like today's session possible, and for sustaining UNODC's long-standing efforts to promote this convention. I also invite the participants to our next events in the webinar series. This Thursday, 18 June, we will have a discussion on the human rights protections under the convention with the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, Professor Bensol. And we will conclude the webinar series with a session on jurisdictional aspects of ICSANT that will take place on Monday, 22nd June, and it will feature Professor Patrick Keenan of the University of Illinois College of Law, the United States of America. My colleagues shared the links for registering to these upcoming events, so we look forward to your attendance at these upcoming online sessions. And please feel free to share it with your colleagues and your professional networks as well. Just to remind once again, more information on all our work related to promoting universalization and effective implementation of ICSANT is available on UNODC ICSANT website. So please visit and make use of that resource. Thank you again to our experts. to the participants for joining the event. And with that, I close the webinar. I thank you.